Hi, my name is Dr. Philip Drum, and I would like to relate the true story of my sister, Rosemary, who was murdered by a driver high on edible marijuana in downtown Seattle, Washington. This occurred in July 2012, 4 months before the voting for Initiative 502, the expansion of marijuana use for recreational purposes in Washington. My sister, a nurse, was hit head-on and her neck was broken by a driver who drove in a center turning lane for an illegal distance at 48 miles an hour in a 35-mile-an-hour zone. At the last second, he realized there was a car directly parked in front of him making a legal turn, and he pulled to the left into oncoming traffic. He then proceeded to have his Jeep lose the front tires and tumble down the road, causing an 8-car pileup. Despite marijuana and marijuana dispensary business cards from the Herbal Health Care Center of Seattle falling out of the murderer's car and witnessed by the lead detective in the case, the family was not informed by the police nor the King County prosecutor that marijuana was involved in this case. We were informed by my sister's automobile insurance company. The prosecutor refused to add the DUI charge for 11 months despite 5 symptoms of marijuana toxicity observed in the murder 3 hours after the event by the DRE officer and a THC blood level of 3.2 nanograms per ml of THC 3 hours and 13 minutes after the event. The DRE officer checked not impaired on his form. This despite the officer not being able to perform any of the physical field sobriety tests. He did not perform a heel-to-toe test, a walk-and-turn test, a Romberg test, finger-to-nose, one-leg stand, or measure pupil size. The DRE officer wrote, due to the incomplete nature of the evaluation, the murderer may have been impaired at the time of the event. Following hiring our own attorney, the King County prosecutor agreed to give the jury the option of the DUI enhanced charge. During the trial, we received the same judge who was overseeing the probation of the murderer at the time of my sister's death. The judge continued to allow him to use marijuana despite overseeing his domestic violence felony, which he performed while he was under the influence of marijuana and alcohol. His first felony was for selling marijuana and cocaine to an undercover policeman. He also had multiple DUIs and driving offenses and 44 court appearances in his 49 years of life. Never once going to trial, all prosecutions ended in plea bargains. The King County Superior Judge failed to recuse herself and threw out the blood evidence because she stated she did not believe the policeman's testimony and the signed voluntary release of blood form. The judge also suppressed information to the jury about the lack of state-required auto insurance by the murderer and his past DUI history. All were deemed too prejudicial by the judge. Due to the judge's action, the jury was unable to convict him to a 16 to 18-year sentence for vehicular homicide with a DUI enhancement. Instead, he quickly received a guilty verdict from the jury for vehicular homicide reckless and vehicular assault, to which the judge sentenced him to 4.5 years. We were informed by the Washington Department of Corrections that he will get out of jail for good behavior after 3 years and 6 months earlier to live in a halfway house to acclimate himself back into society. There will be no probation hearing. There are other victims of marijuana driving crimes. I strongly encourage you to work with these families to have their voices be heard by the public and the media. Proposition 19 in California, the proposition to legalize marijuana to 21-year-olds and older, went down to defeat in 2010. In a post-election analysis, the defeat was partially based on Californians being concerned about marijuana and driving risk. Since that year, the following are a few of the hundreds of people murdered by people driving while under the influence of marijuana. CHP officer McGrory, who as a pedestrian on duty was struck by an 18-year-old high on marijuana who accepted a plea bargain
for a 2.5-year jail sentence. Blake Gaston, the son of a lawyer who, while on a motorcycle, was struck by a vehicle driven by a 33-year-old high on marijuana. The murderer was freed in King County, Washington, at his arraignment with no bail, and has subsequently failed his probation-mandated drug program twice within the past 4 months, and now has a $250,000 bail. Justin Relaford, a 16-year-old pedestrian who was walking hand in hand with his 15-year-old girlfriend, who moments earlier traded places with her, was struck and thrown to his death by a truck driven by a 19-year-old high on marijuana and oxycodone. This murderer served 9 months in jail in King County, Washington, and was released as per his plea bargain agreement, and now has failed his probation and has a warrant out for his arrest for over 70 days and has yet to be arrested by Washington authorities, despite living at home with his parents. Donald Collins, the first pedestrian struck by a truck driven by a 48-year-old high on marijuana shortly after Initiative 502 passage in Washington in December of 2012. This case is still in the Washington courts. Despite the event happening in 2012, it wasn't until January 2014 when charges were filed against the murderer in Washington, despite him having a THC level above the 5 nanogram per ml THC DUI limit. Mr. and Mrs. Thomas Swift. Both were killed when their vehicle was struck by a 24-year-old logging trucker who ran a red light high on marijuana in the Upper Peninsula of Michigan. Despite receiving 6 felony charges, each with a sentence of 5 to 15 years, the murderer will only spend 5.5 to 15 years in jail total, minus time off for good behavior, because all 6 felony sentences will run concurrently instead of consecutively. And finally, retired Dr. Rebecca Twine, struck while gardening in her own front yard by an 18-year-old female high on marijuana, oxycodone, and Xanax. Following a plea bargain, she was sentenced to 3 to 9 years in New York. In all of these cases, it was the murderer's decision to use marijuana and their decision to drive. Their actions were intentional, and now our family members are gone forever. Thank you.